Welcome everyone to our third and final webinar on the 2024 revisions to the EPA's RMP rule. This session will focus on audits, facility siting, and emergency response. I'm Stephanie, your host for today's session. Before we begin, I want to encourage all of you to actively participate in today's webinar. We value your questions and we're happy to answer them. So please feel free to submit your questions throughout the webinar using the webinar Q&A box. We'll be addressing questions during the Q&A session at the end of the presentation. We'll also be recording this webinar, as you likely heard, and we'll make the recording available to you in the next week. If you would like a PDH certificate at the end of the webinar, please email us at contact@accutech-consulting.com. We'll also have this email address up on the screen at the end. Please note that the opinions shared today are only the opinions of the presenters and are not providing any technical or legal advice. But now, let me introduce our speakers who will be guiding us through today's topic. We have Mike Hazen, a senior principal engineer here at Accutech. He is a CCPSC with over 45 years of experience in process safety and risk analysis, security, engineering, and plant operations. He's authored or co-authored several CCPS guideline books on process safety auditing, process safety culture, and security, and contributed to the books on inherent safety and mechanical integrity. David Moore, he's the founder and president and CEO of Accutech, has over 40 years of specialized experience in process safety and risk management. Mr. Moore's expertise includes the management of process safety and security, PHAs, quantitative and qualitative risk assessment, OSHA and EPA compliance, process safety engineering, fire protection engineering, and emergency planning. And finally, we have Mark Farley, managing partner of Farley & Partners, a preeminent national workplace safety and crisis management lawyer. Mr. Farley has served as a lead attorney role for some of the most significant U.S. industrial accidents and transportation incidents in the last 20 years. Mark and his colleagues also counsel clients on chemical accident prevention requirements, including the U.S. EPA Risk Management Program regulation. All of them bring a great wealth of knowledge and experience in the field, and they'll be sharing their expertise and insights with us today. So now I'll pass the virtual mic to Dave, Mike, and Mark to kick off our webinar. Mike? Oh, Mike, I believe you might be on mute. I don't hear you at the moment.
I'm sorry.
There you go.
Thank you,
All good.
Stephanie. Here's the agenda for today's webinar. We have three topics, as Stephanie mentioned. We want to talk about the compliance audit requirements in the new RMP rule, specifically third-party auditing. We also want to describe the change in wording that EPA made to the stationary source siting provision of the PHA element. We also want to talk about emergency response. And then at the end, we have some summary and conclusions that will tie together actually all three webinars that we've given here over the last several weeks. And as Stephanie mentioned, we also want to leave some time for Q&A. Okay, so the first topic is the compliance audit requirements in the rule. And what EPA did is they put in a requirement or added a provision, or actually a section in the rule, requiring when certain conditions are met, third-party compliance audits of the RMP rule. And those conditions that'll trigger this requirement are that if a facility has experienced an event in the previous 5 years that qualifies for inclusion in their next RMP 5-year accident history, then that will trigger the requirements for a third-party audit. Or if the implementing agency for RMP in their region or their state demands a third-party audit because of concerns about the impartiality or the competency of a previous third-party audit, that implementing agency can require a new one. Based on the data that EPA has in the 4-year period between 2016 and 2020, about 3% of RMP registered facilities had an event that they had to report in their 5-year accident history. So the number of third-party audits we don't expect to be high, but it is a measurable number. Now remember, the requirement to do an RMP audit, the owner-operator requirement to do an RMP audit, only applies to the RMP prevention program, which is in subpart C for program 2 sites or subpart D for program 3 sites. The rest of the RMP rule, the hazard assessment, the management system, even emergency response, is outside the RMP prevention program. So you're not required to audit the entire RMP program, only the prevention portion. Okay. So who are these implementing agencies? We wanted to at least point out which states or regions have been granted that status by EPA. You see them here on this map. There are 9 states, and you see the ones that are marked there on the map, and 4 counties in the United States that have been granted the authority by EPA to enforce the RMP rule within their jurisdictions. Allegheny County is essentially the city of Pittsburgh. Jefferson County in Kentucky is the city of Louisville. Forsyth County in North Carolina is the Winston-Salem area, and Buncombe County in North Carolina is the area around Asheville, North Carolina. And as you can see, most of these are clustered in the eastern and Gulf Coast states of the United States. The rest of the states that are not so marked, the implementing agency remains federal RMP or EPA. So beyond the triggering event, what are the other requirements that that EPA put into the RMP rule for compliance audits? Well, there are now 2 things that have to be satisfied when a third-party auditor or third-party audit is done. One is competency, and the other is impartiality. And we'll spend a few minutes talking about those here in a second. These criteria have to be documented. In other words, does the third-party auditor, we have to show that, or the owner-operator has to show that the third-party auditor was competent and impartial. However, the rule didn't stipulate where this had to be documented. Presumably, the audit report will suffice, but we'll see whether there are other methods of documenting the auditor competence and impartiality that will satisfy EPA. So the first of these terms that we want to spend a minute discussing is competence. Now, what the new rule says is that the third-party auditor has to have knowledge in the requirements of the audit element of the final rule. What will satisfy this? Probably experience in doing RMP audits or PSM audits, or work in helping facilities comply with the RMP rule. That'll probably demonstrate the kind of knowledge that's required about the audit element. The third-party auditor also has to be experienced in the type of stationary source, the type of plant and the processes being audited. What will satisfy this? Probably experience in, one or more of the RMP elements, for example, doing PHAs or helping facilities compile mechanical integrity programs or emergency response plans. Work like that would probably demonstrate, again, the type of competence required in that area. They also have to be knowledgeable in the applicable RAGAGEP practices that are found in RMP programs. What will satisfy that? Probably, again, experience doing PSM and RMP audits where, evaluating compliance with RAGAGEPs is a typical practice, and work in the mechanical integrity element in itself. That would probably demonstrate that type of competence. And the final requirement in the rule is that the auditors, third-party auditors, have to be trained and or certified in proper auditing techniques. And the words and or are emphasized here because it's not both, it's one or the other. So what does trained or certified mean? Well, neither the rule nor the preamble that was published in March provided any details on this, but in looking at typical types of audit training or typical types of audit certifications, here are the things that we think might suffice. First, trained. Well, if the third-party auditor can demonstrate that the auditors actually took certain training courses in auditing or PSM auditing or RMP auditing, and back that up with some audit experience that would probably adequately demonstrate that they were trained. What does certified mean? Well, there are several accredited certifications that might apply, and we show them here as examples. Registered professional engineers, which are that certification is granted by the states themselves. Certified process safety auditors, which is an accredited certification from the Board of Global EHS Credentialing. A certified environmental auditor, also a BGC type of accreditation. We think that those will probably suffice because they are directly on point to both process safety or environmental regulations and auditing. Certified industrial hygienists, certified safety professionals, certified process safety professionals, perhaps those will be acceptable as well. We don't know yet exactly what type of certifications EPA will accept, but these are likely to be the ones that they will consider. So the next term that we want to spend a few minutes talking about is impartiality. What does this mean? Well, the first thing that the new regulation specified was that the third-party auditors can't derive any financial benefit from the outcome of the audit, apart from being paid for the auditing services themselves. But EPA did not specify or define what financial benefit means, so we're unsure exactly how they're going to interpret that term. They did state that if a retired employee of the company being audited does the audit and their only financial attachment to that company is an employer finance retirement plan or a health plan, health insurance plan, then that would be okay. The impartiality provision would not be violated by that sort of relationship. And they also said that the audit team leader, at a minimum, has to be independent. The remainder of the audit team, if there is a team, can consist of either other third-party audit firm employees or personnel from the facility being audited. So at a minimum, the audit team leader has to be third-party and independent, but not the entire audit team. There's another provision in the regulation that says that third-party audit personnel cannot accept future employment with the owner-operator for a period of at least 2 years following the submission of the final audit report. This is sort of a revolving door provision that they put into the regulation. Employment for the purposes of that provision does not include performing or participating in third-party audits. That activity would not cause a problem. But any other type of future employment would be prohibited for 2 years. Regulation also said that third-party personnel, auditor personnel, must sign and date a conflict of interest statement documenting that they meet the independence criteria. However, the regulation nor the preamble identified whose form are we talking about. Is it an EPA form that they'll gin up, or is it the owner-operators form that they have to create? Or is it the third-party auditors form? We just don't know yet. So we'll see how that plays out. Most likely it's the owner-operators form, but again, that's an open question. Okay, the regulation also stipulates that auditors have to have written policies and procedures to show that their personnel comply with the competency, impartiality requirements. So they'll have to be able to show those if requested. The responsibility, there are responsibilities in the regulation for both the third-party auditors and the owner-operators. First, the third-party auditors, they have to manage the audit. They have to put together the audit plan, assign the team's roles and responsibilities, prepare the audit report, provide a copy. Typical types of third-party auditing type of responsibilities. But it's the two items there in blue in the middle that I want to spend a couple minutes describing. in a little more detail. What EPA said is where there is a team, the audit report has to document the full team's views on the audit. What they're trying to do is make sure that there's no dispute or disagreement or dissenting opinions among auditors. I suppose that's what that wording means. I've done many PSM and RMP audits over the last 25 years, and I've never been in a situation where an audit team has not been able to reach consensus on the final opinions. But EPA seems to feel that there might be that situation, or it might arise, and they would like it described. So that's a unique and new type of requirement. The other thing that's a bit new is that the third-party auditors have to certify the final audit report and its contents, and the certification language is included in the final rule. Typically, PSM and RMP audits are certified by the site or the company being audited, not by the auditors themselves. This is a change to that practice.
Hey, Mike, let me interject one comment.
Please.
On the sort of the minority report provision is what I call it. You know, this notion that the audit report needs to document the entire team's views. We obviously are saying to our clients who are looking at this issue in terms of how they're going to implement it, this is where you really want to have some very direct conversations with the lead auditor, the independent auditor, and really press to make certain that the team can reach a consensus. I do not think you want to be in a position where there's sort of a majority view of the audit team and then a paragraph discussing the minority view. That's just not going to be helpful to your organization. It's going to create confusion. People are going to come in after the fact and sort of second guess that difference. And so, again, you want to be sensitive to how hard you may be leaning on your audit team leader. But here, I would really press them pretty hard. If there's a view that they're going to have some sort of exception discussion, I would really press them to explain why that is, why the team can't come to a consensus. I just don't like the idea that there's going to be a minority view and a majority view.
No, that's a good point. This is not the Supreme Court where the dissenting justices get to file their own dissenting opinion.
Absolutely.
So you're quite right. And I think audit team leaders, audit teams will work real hard to reach a single consensus. So what is the owner and operator responsible for? Well, they also have to certify the report, as they have done in the past. They have to generate the corrective actions, manage the corrective action follow-up plan, and they have to retain the last two compliance audit reports. Again, typical practice from the past. It's that second item that is new in this regulation. They have to immediately, and there is no definition of exactly what immediately means, they have to immediately submit the audit report to their board of directors or a comparable body if they're not a publicly traded company, or if they're owned by an individual, to that owner. And that audit report has to be submitted to these folks, whether or not it was a third-party audit or whether it was done internally. That's a new requirement.
And again, this is an area where we're having conversations literally within the C-suite of organizations on how this is going to get implemented. I'm certainly coming out of the Texas City disaster and CSB's investigation, the Baker panel. There was a recognition that corporate oversight of process safety and risk management had to improve, and that there was a role for the executive team, role for board of directors in that. But certainly no one on that panel, and I was very involved with it, was thinking that you're going to be sending all of your underlying audit reports to your board. And for very large organizations that might have a fleet of facilities, you could be talking 15 to 20 individual audit reports. Many organizations, even in the process industries, may have directors who are not sort of well versed in how you read these types of documents. And so we're certainly talking with clients about the process that, again, the general counsel or the secretary of the corporation or the EVP of EHS is going to want to set up in terms of how does this information go up to the board of directors? And then, and I can't emphasize this enough, how is there a concurrent report from management about what they intend to do in connection with implementing the results of the audit or the recommendations from the audit? The last thing you want to do is to send this information to your board that highlights a bunch of deficiencies without at the same time providing them assurances, at least on a timeline, in terms of how you're going to respond to those findings.
Okay, good points. Now, what didn't get included by the EPA in the compliance audit element of the new rule? They had a provision in the draft rule that required auditing every RMP process in a triennial audit. They removed this in the final regulation because it did not comport with typical environmental health and safety auditing practice, which is representative sampling. And that's a very common practice. And they decided to remove that provision to include every RMP covered process in the audit. Again, as we stated earlier, the impartiality provision that forbid third-party auditors from having done any work for the 2 years prior to the audit. This was in the draft rule. They also got rid of that provision in the final rule. So it's only the revolving door after the audit 2-year window. The 2-year window before has been removed. And there was also a provision in the draft rule that would have triggered the third-party audit within 12 months of the event that triggered the requirement to do it in the first place, which was an event that qualifies as for inclusion in your 5-year accident history. So you would have had to accelerate your next compliance audit and make it a third-party audit. That provision has been removed. The third-party audit, if it is required, will be on the next due date of your regularly scheduled compliance audit, which is still triennial. So that's the story that we wanted to present on the changes to the regulation with respect to auditing.
Yeah, Mike,
go ahead,
Mike,
Dave.
if I will.
Sure.
Yeah, a couple things that might help. First off, if you go back, to think about whether you need to do an independent third-party assessment or not, Mike said it's based on your incident experience or the directive from the agency if they review your audit and feel it was deficient. But the 3% number, no doubt, came from looking at accident information. So what that would mean would be that if you had an incident from the time you did your previous audit, and they're cycled every 3 years, that qualified, then you would have to ask this to be done by a third party. And so while it doesn't seem like a lot, you do have to think about how relatively low hurdle it is to have an incident that's reportable to your 5-year accident history, and anticipate that this might happen to you, in which case you better be prepared on how you're going to handle it. For one thing, the 5-year accident history is any release that's coming from a covered process involving a regulated substance above its TQ, and it has to cause either on-site death, injury, or significant property damage, which is a bit nebulous, or known off-site deaths, injuries, property damage, environmental damage, evacuations, or shelter in place. So if you had an incident that only caused shelter in place, is it required that you would have to do this? Any comment on that?
Well, it meets those criteria for inclusion in the 5-year accident history, which are in the regulations, the ones you just enumerated, Dave. It sounds like it would.
Right. So I think that the possibility of this might be more than you think. In addition, this is the same criteria that they use for the STAA, for the necessity to do those assessments as well. So I guess it means that we don't want to have any such incidents, number one, that are reportable, because otherwise it triggers a couple of things. And it's a very low threshold, not only by definition, but by the fact it's just one such incident.
Right.
The other thing is, it may not be clear how many of these stipulations that they're making now, such as competency and so forth, are required on your ordinary audit. This does not preclude you having to do your self-audit otherwise. So I noticed one requirement was mentioned that this applies regardless. Do all of these requirements apply?
They only, the ones that, except for the sending of the report to the board of directors, that would be for an internal audit or a third-party audit. All the other provisions that we described only apply to third-party audits when they are required.
Right. So it does set up an oddity where, you could have, like, let's say, less of an audit for your routine ones as opposed to the ones that are required under this third-party assessment, which may create a difference in the outcome. And I think it's something that you ought to think about as well and prepare yourself for possibly, abiding by those kind of rules in the interim, so your studies are very defensible. Just a thought.
Right. Okay, the next topic is stationary source citing. EPA added some language to the PHA element of the regulation to further define what they meant by stationary source citing. The previous regulation just said you had to address stationary source citing, but it didn't define it very well. And what they said is it is inclusive of the placement of processes, equipment, buildings, and hazards posed by proximate facilities. In other words, the nearness, the spatial relationship between where the equipment and the hazards may be located and where the receptors governed by this regulation or protected by this regulation, which is the public and the environment, are located. So other than that definition, sort of that re-emphasis or reinforcement of what the term means, they didn't add any specific analysis or different analysis in the regulation. They just defined it and reinforced the phrase itself. So we need to look at, or when doing a PHA, we'll need to look at where the placement of the processes in the equipment is within the facility and what its spatial relationship, what its distance is to potential receptors off-site. Now, this is very typical currently for receptors on-site. That's facility siting analysis. This will have to now be extended to those receptors that are off-site. It also has to look at the potential for knock-on or domino effects from the site that may then affect off-site receptors. Again, this is something that's going to be addressed in your PHAs because that's where the element where EPA included it. How are you going to do this? What, specifically, what kind of activity will this will take place to satisfy this? We believe that the types of qualitative facility siting checklists that are typically now used in PHAs will satisfy this requirement as long as those checklists include questions or issues about potential off-site effects. So if you've got facility siting checklists that just talk about the effects of occupied buildings on-site, they would probably need to be modified to also include possible effects off-site in order to, and then of course be used during the PHA, and that will satisfy this requirement.
And Mike,
go ahead, please.
One issue that's been percolating along for a couple of years now, and that we think this revision is going to bring to the fore, is sort of the issue of what's a public receptor. And often in some of these formerly integrated chemical manufacturing sites, you now have had the facility in effect carved up into what I call a chemical plant condominium, where you may have one company that operates one process block, another company that operates the immediately adjacent process block. And at least historically, many of our clients have not considered those near industrial neighbors to be public receptors. And we've seen even before this rule, EPA starting to say, no, they're not you. And so that means they're public. And that's an issue where we're going to be watching carefully to see whether or not this revision draws greater scrutiny to that issue, because obviously it has the potential to draw in your offsite consequences in terms of their severity. And it's also, I think, leading a lot of companies to ask themselves, especially if they have very close near industry neighbors, should we be sharing information with our neighbors where we're asking them for their analysis, we're giving them ours, so at least there is a collective awareness of the risks and efforts to mitigate them.
Okay, good point. Now, what EPA did not do as part of this change is they didn't specify, as I said a minute ago, any specific new type of analysis. In particular, they didn't specify any new quantitative analysis of releases to analyze stationary source siting. They didn't modify the hazard assessment part of the regulation. In other words, the section where we do the worst case scenario and alternative release scenario calculations. Those have not been changed. The conditions under which they're required and the assumptions and the data that you got to use to do them have not changed. They didn't make any requirement or add any requirements or modify anything in the regulation that would have changed the facility footprint. For example, adding a requirement for buffer zones or anything like this, or the issue that Mark just brought up about, well, what happens when a facility gets carved up and now it has different owners. They didn't define that, as Mark pointed out. And they didn't address on-site occupied structures in any way. That's still an OSHA issue and a PSM issue. And how we apply the RAGAGEPs that govern facility siting, API 752, 753, and 756 for permanent temporary structures and tents, EPA did not address that at all because that's a purely on-site issue. So all they really did is just re-emphasize that this has to be done, provide a little more definition of what the term meant, but they didn't add any clarity as to what type of analysis will satisfy.
Yeah, and
Okay.
I think that one of the problems is that the whole intent of the EPA RMP is to address these offsite impacts, and a lot of folks, I think, felt like since the prevention program was accepted by EPA, that the typical PHAs that they did were good enough. What I think EPA is doing here is emphasizing that we're expecting you to pay attention to the offsite impacts much more specifically, and presumably do something about it if necessary, make risk decisions based on if there's a school across the fence or what have you. So they were ambiguous about it is the only problem. So I think that it's good, as we just said, to make certain that this next round of PHA revalidations, that you're at least having some documented evidence that you're considering these offsite receptors, if you don't do something more quantitative than that.
Okay. The third topic we wanted to address today is emergency response. The final RMP rule made several changes to the emergency response subpart of RMP. Remember, emergency response is not included in with the other prevention program elements. It's a separate subpart of the regulation. One thing we just wanted to make clear here today, because it seems to be overlooked a little bit, is in 2017, of course, the RMP rule was reissued. It was almost immediately stayed. And then it was actually reversed in 2019 back to its original, 1999 configuration and requirements. But there were a three items in the emergency response subpart that were not reversed in 2019. And these actually apply today as we speak. The first is there has to be some sort of annual coordination between an RMP covered facility and the local responders. The regulation doesn't specify the nature or the method of this coordination, whether it's a meeting or a drill or some other form of communication. Perhaps email correspondence would suffice, but there has to be some sort of annual coordination between an RMP covered facility and its the responders that they rely on offsite. There has to be an annual exercise of the notification system that a facility will use to tell offsite responders or the public that an emergency has taken place, and that then emergency response is required. And that's a communication system, whether it's 911 or some separate sort of horn, siren, or phone system, or however it's designed. That system has to be tested at least annually. And finally, there is a requirement in that 2019 reissued RMP rule, or reversal actually, that stayed in place, and that is that tabletop exercises are required, and the first one is due at the end of 2026, and then every 3 years thereafter. So the first one, the deadline for the first one has not come yet, but it's something to keep in mind. Again, those are requirements that were not part of the final rule. They were not reversed when the regulation went back to its original state in 2019. So what are the new requirements that actually are in the new final rule? Well, you have to develop and implement procedures for informing the public and all the responders and agencies who have a role here that there's been an accidental release of an RMP covered material. Most facilities, because they're subject to actually multiple federal and state emergency response requirements, generally have this already in place. They must provide offsite entities with information about the release so that these agencies and the local responders have the information they need in order to guide their response. Again, because most of the facilities we're talking about already have multiple emergency response requirements in place. That's probably not a new requirement for most folks. But what is a new requirement is the requirement to do, at a minimum, a field exercise, what some folks would call a rollout drill, by March 15th of 2027. So a little less now than 3 years hence. And then perform at least one of these field exercises at least once every 10 years, which is a fairly lengthy amount of time, unless the local responders indicate that frequency is not feasible. I think EPA here is bending over backwards to not unduly burden local responders who have, political and budget issues to deal with every day. So if a responder says, hey, 10 years is too frequent, we can't support that, sounds like EPA will give everybody a buy on that and allow something a little less frequent. But right now, 10 years will become the new minimum frequency for field exercises. And they also put a requirement in the new regulation to issue drill critiques within 90 days, along with documentation of what the action items and recommendations are going to be. Now, again, as I already stated, there are 10 separate federal regulations and a bunch of state regulations, depending on where your facility is, that address emergency response planning or emergency response activities. These include the full gambit of federal agencies: EPA, OSHA, DOT, DHS, and others. So there's lots of attention on emergency response, and most facilities have already devised emergency response plans to cover in one document or one set of documents all of their federal and state emergency response requirements, so that they don't have multiple plans that you're trying to manage and multiple drill requirements and the like. They have condensed their programs down fairly efficiently into essentially one plan. And that includes drills and exercises. It's very common these days in many facilities that if there are multiple regulations, state or federal, requiring an exercise of one sort or another, they combine them. So, for example, PSM and RMP drills generally are done together. PSM RMP drills and those required by the Department of Homeland Security under the CFATS regulations for security types of events. Many times those are also combined into one type of exercise. So that's the sort of the surrounding issues that are in play here in emergency response. The new requirement, the major new requirement, is this every 10 years field exercise, which is, we haven't seen that requirement before.
And folks should know, again, it's sort of some inside baseball. We are seeing EPA, when it's participating in these types of drills, being a lot more assertive, a lot more confrontational, even in the context of the drill. In talking with folks at the agency, it seems that may be an outgrowth of the train derailment in East Palestine, Ohio, where EPA now feels that it is being criticized for its role in the incident command and whether or not it was pushing back enough on decisions that were being made or challenging decisions that were being made. And what we're at least hearing from the agency is that the word has gone out to folks who are representing EPA in these, that they really need to be a little bit more combative in terms of accepting the information that they're getting from the owner-operator, for example, just so the agency can come to its own independent judgments about a course of action.
Okay. Now, the final RMP rule did not alter one of the basic choices that's in PSM and RMP, and that's the choice whether to be a responding or a non-responding facility. That choice still remains in as part of the emergency response requirements for both regulations. But there is a question, and this question, by the way, is not a new question. It's existed for a while. Now, what happens if the coordination that is now formally part of this regulation with the local responders is not productive? What if a facility makes a good faith effort to reach out to their local responders, but for one reason or another, the local responders don't respond to that reach out, or don't cooperate in doing drills, or don't cooperate in doing mutual aid, or whatever the facility is trying to get them to do, or at least respond. Will EPA then put the burden on providing all of the response with the owner operator if the local responders do not respond, even response to do the planning part, let alone the actual response if there is an emergency? So, I mean, there's some unanswered questions about what happens in some with some facilities when their local responders are just not cooperative. And in several areas, this is not going to happen. There are well-established local emergency planning committees and other, well-organized, independently funded, in some cases, response organizations like what you have along the Houston Ship Channel and other similar areas around the country. Those types of situations, we're probably not going to have this question. But in more rural areas where, say, it's a volunteer fire department only, that may be a little more difficult in terms of getting the local responders to fully cooperate. So we'll have to see what happens there. Okay, a little bit of summary here. In our last 3 webinars, including this one, we've covered an RMP, an overview, I should say, of the RMP rule. We've talked about STAA in detail in the second one, and today we presented these 3 topics. But there are other changes, and if you attended our first webinar, we at least summarized these, and you see them here on the screen. Everything from incorporating natural hazards and loss of power into your PHAs, how you describe the status of PHA recommendations, analysis of RAGAGEPs, the differences between what was used to build or design or build a particular process and what the same RAGAGEP says today. Backup power for monitoring devices, doing root cause analysis during your incident investigations, a strengthened employee participation element, and a fair amount of changes on how the public can request certain types of information from an owner or user, or I'm sorry, an owner operator. All of those were addressed in the final RMP rule and are in place. So those are things that we just wanted to remind everybody of what those changes were. Now, what didn't change in the final regulation, we just want to spend a second covering these. The covered substances, the chemicals covered by the regulations and their threshold quantities did not change. So the applicability of RMP was not altered by this final rule. The definition and application of the 3 RMP program levels, 1, 2, and 3, their definitions did not change. The registration and the RMP submittal requirements have not changed. As I said before, the requirements for doing worst case scenario and alternative release scenario calculations have not changed. And EPA had been considering 3 other changes that they did not include. One was extending the mechanical integrity requirements to cover not just process equipment, but any safety critical equipment, including utility equipment. They didn't include a definition of a RAGAGEP, which they had said in an earlier Federal Register notice that they planned to do. And they did not require or add any requirements for management of organizational change. So those are things that were on the table, but did not make the final regulation. We covered this during our overview, but we wanted to repeat it here just to remind everybody the timing of these new changes. The effective date of the new rule was May 10th of 2024, about 3 weeks ago. And everything is measured with respect to that date. Most of the requirements, the STAA requirements, the root cause analysis, third-party audits, emergency response public notification, all those kinds of things, the information availability requests from the public, all those become effective 3 years from the effective date of the rule, which will be May 11th of 2027. The revised requirement for the first and subsequent emergency response field exercise. First one's due by March 15th of 2027, and then every 10 years thereafter. And there is a provision in the regulation to take credit for drills that were done between March 15th of 2017 and the effective date of the reg. So you can go back if you did a field exercise and take credit for your first one there. And then everybody gets 1 more year beyond the 3rd year anniversary. That is till May 11th of 2028 to submit their first revised RMP online. So that's the timing. What they were not specific about were in the final regulation or the preamble was the timing for revising your PHAs to take into account natural hazards and loss of power analysis. Presumably, the next scheduled PHA revalidation after the effective date of the regulation, again, May 10th of this year, should include these requirements. But it was not clear in the regulation whether that was the case. Final conclusions. There's just 3 points here that we want to stress as part of our final conclusions. The first is that for the first time, the RMP prevention program, the basic RMP elements, and the PSM standard will now diverge. They were identical for over almost 25 years. Now they will start to diverge. They have started to diverge. And OSHA announced at the CCPS conference in late March that changes to the PSM standard to bring it into alignment with the new RMP rule are not a priority for 2024. So this divergence is probably going to exist for a while. The next conclusion is that for the first time, EPA used the results of the worst case scenario and alternative release scenario calculations for some other reason in the regulation. In this case, was to set the 1 mile criteria for whether you have to do an STAA or not. That's the first time that EPA ever used that data other than to simply collect it and tabulate it for any other purpose in the RMP program. So it begs the question, what other future uses of this information do they have in mind, if any? And finally, the final RMP rule will be the first time that any federal, state, or local process safety regulator has included mandatory risk reduction measures as part of a final regulation. And as Dave described during our second webinar, that's part of the new STAA requirements. This is a major departure in process safety rulemaking. It's the first time we've seen a regulator do this. So those are the main conclusions that we wanted to stress with you here today.
Right, and we did discuss those in 2 prior webinars, as you may have heard earlier. Those are freely available to you, and Stephanie will send out a notice that'll include a link to all the 2 prior ones that we did, and including this one, so that you're free to review this at your leisure and pass it on to others if you'd like. If there's any questions, you can ask us following this webinar, but we do have a number of questions right now. Maybe we could take the last 9 or 10 minutes here and go through some of those. The first one talks about, a 5-year accident history between 2016, 2020. Was there any misreporting, and do you think they're tightening up? They're definitely forcing indirectly anyways, a tightening of the requirements for reporting, because they've tied 2 important stipulations, this third-party auditing and the STAA, to the incidents, a single incident. So it would be very important that you could prove that you did not have a single incident on their inspection if they were to visit. There's other ones in the questions, if you could look at them and see if any of those would be something you'd like to bring up. There's one about, do field exercises require participation of outside responders? I believe that's the intent. Exactly what to do is not specified. So, the idea would be that whoever the responder is that's relevant to your facility, to your processes that are covered, would be the point of contact, and that you would discuss what is a relevant exercise and drill, and you'd be sharing information. The point about EPA making explicit that you need to share that information, I think, goes back to the West Texas incident, where the unfortunate death of a number of firefighters was presumably contributing to that was their lack of knowledge of how to deal with it, and what exactly they were, what the potential was of the incident that they were responding to. So that's, I think, what is driving their interest in that.
Okay. There was a question about whether the regulations specified which scenarios that have to be included in the facility siting or stationary source siting analysis: vapor cloud explosions, fires, toxics. They didn't specify what types of releases would have to be analyzed for its potential stationary source siting impacts, but presumably it would be the same types of events that you would include in the PHAs, which are for, since this is a process safety regulation, vapor cloud explosions, certainly, fires, yeah, certainly, and of course, any kind of toxic gas release, certainly. But there may be other types of scenarios that you include in your PHAs that might have an offsite impact, and you would have to look at those as well. So again, they didn't specify which types, but the types of events that cause process safety impacts, I think, would be the ones that you would have to focus on. There's an interesting question. I don't know, Mark, whether you've seen anything on this. If a facility gets involved in emergency planning with a local responder, would they be subject to help with the mitigation costs? I haven't seen that yet, Dave. I don't know whether you have, but I don't know, Mark, in your work, have you ever seen somebody be subject to the cost of emergency response simply because they had to coordinate with local responders?
Just to coordinate, no, but obviously if you have an incident, you can be liable for the response costs by virtue of a number of federal and state statutes. But I've not seen it just in the planning side, Dave, or coordination on drills.
Okay, there was a question whether qualitative type checklists, facility siting checklists, meet the requirements of API 752, 753, 756. Those are independent RAGAGEPs. They're separate RAGAGEPs. And there are requirements in there for quantitative analyses. They only have to be done once. They're not part of the PHA element per se. They relate to the same topic, which is the vulnerability of on-site occupied structures to various types of explosions, fires, or toxic gas releases. But EPA in this regulation made no reference to those RAGAGEPs, nor did they make any reference to how you do the stationary source siting. They did make it part of the PHA element, so presumably, hopefully, the qualitative checklists that are typically used in a PHA revalidation to address facility siting will suffice to address stationary source siting, as long as those checklists include some questions or issues related to possible offsite impacts. But we'll have to see how that plays out when they start to enforce this.
Yeah, we've seen a lot of PHA studies that don't mention anything about offsite. It's almost like their only concern is on-site, and again, they're dual purpose. You have and don't forget that EPA believes they have authority over on-site events because they lead to offsite. So the whole point of prevention, if it was only the impacts, they would only be worried about the emergency response element. So they're worried about it as well, and they have authority there. So, they just haven't been all that fussy up to this point about that. But our observation is that a lot of PHAs, more or less, you can't find any reference whatsoever to the offsite impacts that are undoubtedly there on certain types of events, especially highly toxic, long, impacts of say blast overpressure or radiative heat flux going over the fence line, and it's not normally mentioned. So the point is that this has to address it in some way or fashion as part of the PHA process. It could be in the facility siting study. That could be in the stationary source siting discussion of that facility siting study or PHA, or it could be embedded in the PHAs itself.
Right. Someone had a question here. We're almost at the end here, but one more, I guess. Any thoughts on how to define proximate, which is a word that they use in defining stationary source siting? They didn't offer any guidelines. They didn't offer any rules of thumb on how to determine whether an event would be, or the spatial relationship between where the event occurred and where the public or the receptors were proximate. But the same types of thought processes and rules of thumb that are used to determine in a facility siting analysis, in other words, whether an on-site occupied building could be vulnerable to whatever the scenario is they're discussing, if you use the same rules of thumb, the same discussion process, the same conclusion process, and if that results in that event crossing the facility boundary and extending out into the public, as defined by Mark a few minutes ago, that may be actually an on-site unit, or used to be an on-site unit. If it extends that far, then that would meet a definition of proximate in this case. But there are no numerical guidelines that EPA has offered to help people define what proximate means.
Yeah, it's an excellent question, and I don't mean to be glib in my response, but it's the sort of thing that there may not be clarity in the rule, but if you're holding a plot plan that shows one of your concentric circles from either a fire, an explosion, or a toxic release, and it's over that adjoining facility, the agency is going to look at that and say, that's definitely proximate. And so
Right.
you're almost going to back into the conclusion once you start to have a sense of what your potential impacts are.
Right, right. Okay, well, we've reached the 1 hour point. Stephanie?
Yeah, so this webinar was the conclusion of a series of sessions on the revisions to the RMP rule. I want to extend our gratitude to the three of you, our speakers, Dave, Mark, and Mike, for sharing their expertise and shedding light on upcoming changes. I also want to express our thanks to each of you for joining us today and on the previous webinars. Your active participations made all of these sessions really engaging. We'll be sending out a link to the recorded webinar once it's available. Feel free to revisit the content, share it with your colleagues, or delve deeper into the insights that we provided today and on the last two. We'll send an email with this recording, but also the other two recordings and the associated white paper in the coming days. If you need a PDA certificate, email us here at the email you see on the screen. And for those of you who submitted questions, there's just a couple that we couldn't address during the sessions. Don't worry, send this to the team and they'll follow up with you individually. And once again, a big thank you to our speakers and to all of you for being a part of the conversation over the last few months. We look forward to connecting with you all again in future webinars. Thank you.
Thanks, everybody.
Thanks very much. Bye-bye.